Today, we're following a contempt hearing about years of flooding on private land. The property owners say the state of Ohio caused flooding and, in doing so, took away the use and value of their land. Because the state never filed the claim it was supposed to file, the owners still haven't received any compensation. During the hearing, the justices questioned the state about why so little progress has been made, why the process has dragged on for years, and how some owners have passed away waiting on a resolution. The hearing reaches a turning point when the justices begin examining the appraisals closely.
That list of appraisers, you've got to be an MAI or
state certified. You basically need to be state certified.
okay, and if they have more than one appraisal at different numbers that have gone through their review process and both deemed to be legitimate, I think they're permitted to file on the lower number, the deposit.
I believe there may have been a change in the law since that was the case. I believe the law now requires that the appraisal be done, a good faith offer in the amount of that appraisal be done, and then a deposit is made. For example, by ODOT on a quick take, a deposit is made in the amount of that appraisal. It's required.
When the state takes land, the deposit is not optional. It's a safeguard. The money is supposed to go into the court immediately so the owner isn't left waiting. Not doing so means the owner loses access to money the law already says is theirs. The delay raises questions since most agencies handle this step early on.
And the importance of the fact that they have not made these deposits in the last 6, although they did in the first 2, is that we've had 3 of our clients, realtors, who have died since this action was brought.
These cases cause real-life harm. When property owners expire before compensation is paid, it complicates everything. Estates step in, paperwork increases, families wait even longer. Courts try to avoid delays that cause this kind of outcome. This is why this point hits so hard.
We will probably lose more than that by the time these cases are tried. Without giving these landowners the benefit of that deposit, a deposit based upon what ODOT admits is the fair market value
Natural
of what they're
resources.
taking. Excuse me, natural resources. Thank you, Your Honor.
Counsel, let me ask you a question. It was represented that, in this case, time is working against the state because of the increase in value in this property per acre. It's increasing over the last year or so.
Rising land values really change the power dynamic. The higher the value, the more expensive it becomes for the state to settle later. The justices are trying to figure out whether the delay is financial, accidental, or even strategic. They need to know if the slow pace benefits the state at the landowner's expense.
So what is their motivation, in your estimation, as to dragging their heels and proceeding at this pace?
Well, Your Honor, I'll answer that question as best I can. I don't know what their motivation is. I have my own views of that. The fact is, we were only $3 million apart when that $24 million
plus some objectionable conditions from what we heard from opposing counsel.
Well, the condition that we made on our offer was that once the surveys were done, if those surveys showed substantially less than what we believed were acreages subject to flooding, then we said we want to be able to make an adjustment in that amount, not a substantial adjustment, but some adjustment. If, for example...
So what motivation did they have then to settle early? You settle early and then say, but give us what we deserve even if we settle early. That's not negotiation.
The reason for that is we agreed with ODOT that there was approximately 4,800, ODNR, we agreed with ODNR there was basically 4,800 acres affected.
Acreage is how the compensation is calculated. If more land is flooded, the payout is more. The landowners say the flooding pattern is already clear from years of data, so the state should roughly know how much land was affected. The state wants every single property formally surveyed first, which takes a lot of time.
We agreed with them months and months ago, last spring. There was 4,800 acres affected. And the offer that they made of $5,000 an acre was based upon that 4,800. We knew that surveys were going to be done. We didn't want the surveys to wind up being, say, 3,000 acres. And then they say, oh, well, we're only going to pay you $5,000 an acre for 3,000 acres, as opposed to the 4,800 that we believe.
So basically the disagreement was over the acreage affected, not some future damages to
Correct.
different properties, or this will not be a complete settlement for this owner based on this owner's property, and the next time a flood comes and affects more property, they'd be precluded from asking. That's not even on the table.
Not on the table.
So it's whether it's going to be 4,800 acres or whether it'll be something less than that.
And frankly, Your Honor, and I will tell the court this openly, we were in a whisker getting this matter settled when that $24 million was pulled off the table in August, just yanked off the table. We waited for 3 weeks.
This was only for the agricultural clients?
Correct. We had six.
And how many non-agricultural clients?
A half a dozen.
And their property is residential?
Residential, and there's commercial as well.
Okay, and so they would be excluded from this 4,800 acre settlement.
Correct.
And what was your proposal for those clients?
We asked for an additional $3 million for those clients.
To be divided amongst those clients exclusively.
Amongst those clients. Correct.
Okay.
And again, we thought we were in the middle of good faith negotiations when we were told not only is the $24 million not available, we're going to make you try every single one of these cases. And now we know there are going to be all 53 of them at best will be filed by the end of next year. Many of my clients will not see a penny under that scenario.
The court is frustrated. If the state waits until next year to file all 53 cases, the trial would drag on for years. The original order wasn't about deciding who wins. It was simply about getting the process started. By moving so slowly, it looks like the state is avoiding taking that first step.
Because it is definitive that the governor's office will not approve any global settlement. That's what you state in your brief.
That's my impression. I can't say for certain whether that's the case, but that's my impression.
Because part of your argument is that this was a stringing along process because there was an inference that the governor's office was cognizant of these negotiations.
Well, we in fact were told on June 29th in a letter from one of the attorneys general that's here today that led us to believe that they had in fact received the governor's office approval and reiterating the $24 million settlement. That's why we were absolutely flabbergasted.
Big settlements with state agencies usually need approval from higher offices. If that approval changed or if there was some kind of breakdown in communication, that would explain why the settlement suddenly fell apart. The attorney can't directly blame the governor, but he's clearly suggesting that something might have shifted behind the scenes.
When on August 16th or 9th, I can't remember it precisely, but whatever date it was in August when we, after requesting a meeting, what's going on, we were told it's off.
But you had not accepted the $24 million, and you had not accepted the $24 million. You were putting additional conditions and a demand on.
Well, we had demanded $27 million, but
so at any time that you don't accept, your party's free to withdraw an offer.
Well, let me answer that question this way, if I might. The fact is, what we were offered in the $24 million was contingent on a whole number of things, and I would call it basically a trial balloon. Would you accept $5,000 an acre? And we negotiated in good faith and floated our own trial balloon. Well, if you pay us for the people who were not included within the original offer, $3 million, $27 million, we've got a deal. We made that offer to them. And And then 3 weeks later, after we made that offer, it was theirs was completely pulled off the table. So
let's move this to the what you said was a sticking point when the state approached you they approached you, first of all, on the global settlement.
They approached us when we threatened last May to file the contempt motion. Okay,
now, you said the one worrisome thing in that discussion was, what are the surveyors going to ultimately determine are the total gross acres affected? The surveys are now all done?
No, there's 20 that are not done.
Those missing surveys are a major roadblock. Without knowing the size, no one can accurately calculate the compensation. It also makes any settlement harder since both sides are essentially guessing. Having so many unfinished surveys is very unusual.
So you still don't know the gross acreage?
That's correct. There are 20 surveys that are not done, and we can only assume that as to those 20 parcels of property, they're not going to take them ultimately.
They're not what?
They're not going to take them. If they haven't completed those surveys by now, a year later, our assumption is they're not going to take them. So unless ordered by this court.
Where do you believe you are in the acres that they are going to take?
Well, if they follow through on the understanding that we had that it was 4,884 acres, we're going to be in agreement. They have never told us that they can't figure out how many acres are involved or how much property needs to be taken. They filed numerous cases before this group of cases in another, as a result of another mandamus action, without any dispute over what the flowage easement is. If they want to sit down and ask our clients about the flowage easement, they've taken all of their depositions. We're more than willing to do that. They have yet to go to the Court of Common Pleas and ask the Court of Common Pleas to resolve the dispute. Frankly, again, I will just state that that issue is a complete red herring.
Mr. Ingram, we're talking about a contempt order, and we need to see clear and convincing evidence before there's any finding of contempt. And when you read the order and it said that they shall institute the proceedings, it seems to me, if I'm listening correctly to what you're saying, that you're disagreeing with the manner in which they have proceeded, but not the fact, there doesn't appear to be evidence that they have done nothing. Am I missing something here?
Yes, I believe so. Respectfully, Your Honor, we read this order as requiring that condemnation proceedings be filed, not just that they go through the motions on some of the cases at their leisure.
Does it say condemnation proceedings must be filed?
Appropriation proceedings, and I can only read that as condemnation proceedings. That's correct, Your Honor.
They disagree on how to interpret the word initiate. The landowners say it means the cases must actually be filed. The state says doing the prep work is enough.
And if you're asking what's clear and convincing, I guess all I can do is just look at the results. 1 year later, 1 year and 3 days later, how many out of the 53 appropriation actions have they filed? 8, 6 within the last week. Only under the compulsion of this court will ODNR follow this court's writ of mandamus.
When a city decides to take, or a state entity decides to take a property, what is the normal period of time from this decision when they say, okay, we're going to take your property, to when they actually file the case?
Well, Your Honor, I do a lot of Ohio Department of Transportation taking work for landowners, as does Mr. Stokes. What I can say to that is when the state wants to, when they want to take property, whether it's for a highway or some other public purpose, they get those appraisals done and those cases filed promptly.
And that does not answer my question at all.
Well, I can't, I'm sorry, I can't give you a
you have
time
to have,
period.
in every case, you have to have a filing, a decision, what is going to be taken, a survey, an appropriation, an offer, a 30-day period. none of that can happen in 30 days. That is a period of time that takes to happen, does it not, in every case?
Yeah, I'm not suggesting it can be done in 30 days, but it certainly can be done when the will is there to do it within a matter of months. We're talking 97 parcels. Any county auditor would be able to appraise 97 parcels of property in a matter of weeks.
How many parcels involve an entire taking?
Unfortunately, this hearing didn't end the fight. It took several more years before many landowners received any compensation. Each property had to go through its own separate case. Some owners were eventually paid, but the process moved very slowly.